Hello, everyone, and welcome to our Business Building Q&A. I'm Mike O'Neill with Bench Builders, and I'll again be your host for today's Q&A session. Joining us from Chattanooga, Tennessee is our expert panelist, Dan Gilmore. Welcome back, Dan.
Thank you very much, Mike. Great to see you again, and Rhonda as well.
Well, you mentioned Rhonda. We're going to be hearing from Rhonda. Rhonda's going to be kind of responding to some of the important employment law updates that Dan's going to be sharing. And we're glad to have you back. Welcome, Rhonda.
Thanks, Mike, and thanks for joining us again, Dan. We're really excited to hear some of your updates, and I know everybody else will be intrigued by some of the new things just recently happening. So thanks for being with us.
My pleasure.
Well, we launched these Q&A sessions really with one intent in mind, and that is mindful of the folks that we typically work most closely with, which are business owners, key leaders, and HR professionals, because they were asking us questions, and we said, well, you know what? Let's get together on a regular basis and see if we can provide some answers that will help you build your business. We set this up as a format using less of a webinar and more of a Q&A. And so if you haven't already, open up the chat box, and if you would click the blue box that says panelists and attendees, and as you have questions for our experts, write those down. And my job as host is just to kind of monitor those and hopefully work in your questions while we're together live this morning. We are recording our time together. And so if you're not joining us live, you will get an email, and that email will have a link to the recording. It will also include the slides and the contact information included on that. So with that in mind, before we transition to our expert panelists, we're going to test out this chat box. I'm going to get y'all comfortable with doing that. But we started this series when COVID hit and hit hard. And this has been a tough 6 months. And sometimes what you got to do is just find ways to relax. Here's my question for y'all. We just got through the Labor Day weekend. Our hope is that you had a chance to spend time with family, spend time doing things. Share with you, if you don't mind, share with us the kind of things that you might have done for fun over the Labor Day weekend. Give us a sense that, one, you know how to use the chat box, and two, let us hear from you. What did you do over the Labor Day weekend for fun? Dan, did you do anything fun while we're getting these responses?
Well, my wife's birthday was Monday, and we spent some time out at Nickajack Lake on some paddle boards and kayaks, and just chilled and enjoyed the remarkable weather. So that was fun to get out in the outdoors and spend time with some very good friends and family. So yes, that was a highlight of the weekend.
All right, glad to hear that. Rhonda, did you get a chance to have some fun over Labor Day?
We did actually. Finished up a week-long vacation in Hilton Head last week and ended with a visit to our daughter and son-in-law's house to see them and our grandkids, and actually back here on Monday to do some boating. So very fun-filled weekend.
Man, it does sound fun. Matter of fact, it looks like boating's kind of a recurring theme. It looks like Deborah spent time with her family and hiking. Carly was able to do some boating. Randy moved your daughter into her first home. How very, very cool. I know that was work, but I hope that was fun as well. And Dan, let me see if I got this right. Spent 24 hours sitting on the dock by myself watching the boat parades. I hope that was fun for you, Dan. 24 on the dock for 24 hours. Man, oh man. And Charlotte, my husband and I rode our Harleys on Monday. It was a beautiful day. It was a gorgeous day. And Jackie said she worked in the yard. That can be work, but for me, it does kind of recharge the batteries. Let me tell you why I asked this question, and that is, what has happened over the last 24 weeks or so is we have built community. And in building community, it's important that we recognize there is life outside of work. We really want to be mindful of that, and what we're encouraging you to do, particularly as leaders leading in a very, very tough time, don't forget to take care of yourself. Don't forget to encourage your employees to take care of themselves. We've got a lot to be thankful for, and taking the Labor Day weekend to do so, hats off for y'all to do just that. With that in mind, I'm going to transition to our guest panelists, and we've got Dan back with us. For those who were with us early in the process, our 8th webinar, Dan was our expert panelist. And Dan did a fantastic job taking all of these new things were coming our way very, very fast, particularly with legislation, and putting it in language that it's much more easier to understand. Also, what we've learned is that everybody knows Dan, and it looks like everybody loves Dan because we had a great registration for that session. And so it seems obvious that we would invite Dan back, because between March and now, a lot has happened. So Dan, welcome back. We're glad you are with us. We have listed that we're going to ask you to speak on update on what's happening in the legal profession. But for those, here's a nice clean shot of Dan, clean shaven. But hey, Dan, welcome back. We have you listed here. The name of your firm is Squire Strategies. So I've got to ask the obvious. Why did you choose, as a lawyer who consults with business on legal and other matters, what is it about Squire Strategies that led you to believe this is a good company name?
I'll give you the shortest version possible of that story, Mike. I had a client in California. 10 years of my practice in this area of the laws was in the Republic of California. I'm not sure if we have everybody on the call from there, but my client there asked me at one point, why do lawyers have Esquire at the end of their name? Why is that? What does that mean? And I said, well, Gary, that comes from the word squire. Squire is the person who would accompany the knight, carry the knight's shield, sword, protect the knight, defend the knight, who was indispensable to the knight. And he says, great, you're my squire. I said, okay, from that point on, he was Sir Gary, my knight. So the squire is the concept of protecting my clients, and it also indicates the proactive nature of my practice. I would rather anticipate issues and address them before they become problems and not be reactive. And so that is the genesis of Squire. I didn't want to use Esquire, it sounded too formal. So Squire Strategies it was, and I've been practicing under that name since April of 2013.
So you've been practicing under that name since 2013, but you've been a lawyer for how long?
Originally licensed in 1987. I was in the Marine Corps as judge advocate in the Marine Corps for several years. And then I've been in private practice now since 1990 and practicing almost exclusively in labor and employment law since 1991. So coming up on 30 years in this area of the law, which I find fascinating. I've taught for the last 7 years at UTC, 2 courses, which are both, as you and Rhonda know, online this semester, like a lot of university courses. But it's an area of the law that I've always enjoyed. And as you mentioned, it's ever changing, especially this year.
For those who are not from this region, UTC is the University of Tennessee at Chattanooga.
Correct.
And so I need to now start calling you professor on top of all the other titles you have. You weren't anticipating the question I just asked, and you're not going to anticipate this next question. So here's where I'm going to go with this.
Okay.
We kind of view that mid-March is when COVID hit as hard as it did, and it kind of turned the business world upside down. And as leaders listening in on this webinar, if you were to kind of take a snapshot of just the climate that you're seeing from March to now we're into September. We're going to get into some specific questions in a moment, but on the whole, what are you seeing with your clients that kind of sets the stage for our time together?
What I've seen is continually adjusting, readjusting, responding, in many cases, just trying to survive, keep people employed, make sure nothing slips through the cracks procedurally, policy-wise, but just in survival mode. And so thinking back when I was your guest back in May, it just astounds me that it's 4 months later. It just has been a blur to me, to my clients. And as we begin to emerge, hopefully that's the way I see it, and work toward more of a normal business world, hopefully we'll have the opportunity coming in, although the fall is approaching fast, but it's been really a matter of focusing on the basics and making sure that employees are looked out for and are retained. And if they have to be furloughed or laid off, bring them back as soon as they can. And part of that, there's incentive for that through the PPP, those who have taken advantage of that program, which has been very helpful. But like we'll talk about with the federal leave in a minute, a lot of the programs were designed to last until everything was anticipated to be behind us by, say, midsummer, but unfortunately it's not happened. So my experience has been helping clients just get through this. And then when we have the luxury of looking at other things that are probably more considered to be more optional, then I look forward to that like we all do.
That we do. I mentioned a moment ago that it's COVID that brought us together initially, and we're still in the midst of COVID. Little do we think that we would still be having this conversation 6 months in. But what we've done in that 6 months time is people kind of know, this is a Q&A. Let me go ahead and get my question in because I want to get some answers. If you don't mind, we're going to jump right in.
That's what I'm here for.
We're going to jump right into some questions that we've gotten before we began recording this today. And some of them make reference to some abbreviations. One of them is the FFCRA. And I hope I'm going to say this right, but that does stand for the Families First Coronavirus Response Act. And,
correct.
All right, thank you. But going forward, for the next time, if whatever we have time left here, I'm going to be calling it the FFCRA. And then you made a reference to the PPP. The 3 P stand for?
Payroll Protection Program.
Okay. There may be other abbreviations that we encounter, but let me read this first question to you, Dan. And it reads something like this. My employee has informed me that he has tested positive for COVID, or he's been in close contact with someone who's tested positive. The question is, how long should I keep him away from work? And does the FFCRA apply? Does that question make sense?
Yes. Okay. Thanks, Mike. I'm going to start out by hopefully explaining the difference between two critical words that throughout these last several months often get used interchangeably, and including by, as we'll talk about in a minute, by the Department of Labor, unfortunately, which doesn't help with clarity. But I'm looking primarily from the CDC, the Centers for Disease Control and Prevention, two terms, quarantine and isolation. And so both of those come into play in the question that you posed. Quarantine, just to differentiate between the two, is keeping someone who might have been exposed to the virus away from others, like the second part of your question. And isolation addresses the first situation, someone who is infected with the virus, keeping them away from others. And so in terms of isolation, let's talk about isolation first. If the employee comes to you and says, I have either have symptoms and I'm certain I've got COVID, or I don't have symptoms, but I went and got tested for whatever reason and I'm positive, what do you do now? So that is an issue of requiring isolation. So isolation in that situation with that employee is the primary objective from the workplace is to keep them out of the workplace, keep them away from employees. And if you've got an employee who works out and about in different locations, keeping that employee away from your customers, your clients, others who your business relies upon. With the situation where they do have symptoms and they know they've got it because they have symptoms, the key amount of time there is 10 days, keep them isolated for 10 days since the time those symptoms first occurred. And then at least 24 hours after they stop having a fever, which is in this context is 100.4 is kind of the magic number. And then once their symptoms start subsiding, it's safe to bring them back to work and let them have interaction with your other employees. The second situation, they are asymptomatic, but they have tested positive and they've come to you and say, what do I do? You need to isolate them again. That's the key term to keep in mind there. And they need to remain at that point in isolation for 10 days from that positive test. And some employees may say, well, my doctor says I can get tested and I want to come back to work more quickly if I get some negative test. Be careful about that. The CDC recommends that before you do that, you'd have to have or should have 2 negative tests in a row that are at least 24 hours apart. Because we've all seen information about testing that may not be entirely reliable. So the safest course of action would be to keep that employee isolated from the workplace for that period of time. Now, the second situation, dealing with someone who's had close contact with someone and is concerned about that, that becomes an issue of quarantining, because that employee needs to be kept away from others during that period of time to make sure that employee has not become infected, to protect them from becoming infected. So that is a example of when quarantine comes into play. And that's where the magic number for quarantine is 14 days. So literally to the hours, what the CDC says. So if they come to you and say, I had close contact with someone yesterday, their quarantine should begin then and then go for 14 days. When I say close contact, this may be repeating what most everybody understands, but we've all heard within 6 feet, within 15 minutes is the magic time period. They've had to care for somebody at home with COVID. They've been sharing drinking utensils. These are all alternatives. I mean, these are not, you don't have to have all of these. Or you've hugged, kissed somebody who you now know has COVID, or someone has coughed or sneezed and you feel like I got these droplets that are on me, so I've got concerns. So that is when that 14 days is relevant. And where you need to be careful is, I had a situation recently where a client had an employee who had concerns about being affected by family members. And so the quarantine is what they need to be mindful of. But if you've got multiple people in your household and they're becoming affected, there's a possibility of having to start that 14-day clock over and over again. Every time they've had close contact with someone, they need to restart it. So there could be, you may have seen, and those on this meeting may have seen the number recently that kind of shocked people. It could be as much as 24 days, the 10 days for isolation plus the 14 days. And that it could be even more than that in some situations. So the important thing there is to keep in mind, isolate when you need to for those periods of time. And if the employee has not been infected, quarantine them for that period of time. On to the next part of your question is, how does the FFCRA fit into this? And to comment upon the initials, there, I think employment laws is unique or remarkable in the sense that there are initials for everything. There was one CLA recently, I saw that the alphabet soup of employment law. So there's all kinds of initials, but FFCRA does have provisions for an employee in this situation to be entitled to up to 2 weeks of paid leave is the basic requirement. Now, what's happening in a lot of cases is employees may have that entitlement, but they, or at least started out April 1st with that, but have already used it. Like I mentioned before, and we'll talk about in a few minutes about leave to take care of kids at school. A lot of employees have already used it up. Even though this is still in effect till the end of the year, there are employees who've used their 2 weeks of paid leave already, and so they may not have that available. But if they do, if they are being quarantined or isolated at the direction of a healthcare provider, then they are entitled to it. And to be honest, the language in the statute itself is not really clear about what do you do in terms of paid leave for someone who is tested positive, or they've been waiting for the results of tests, which is covered, but now they know they're positive. The statute itself doesn't really address that, but I would point out to those in this meeting that the questions and answers that Department of Labor has provided indicate that that person who is positive, who's in isolation because of that, would be entitled to the leave. It's one of many areas where the regulations, the question and answers don't necessarily match up with the statute, but I would recommend that if you have an employee who is positive, who is being isolated at the direction of a healthcare provider, that they be offered the opportunity to take this leave. And so, and also it's important with this type of the 2 weeks of paid leave for those who are ill or being quarantined because they may be, that applies to employees from day one. So if you have an employee, first day on the job, they come to you and say, great to be here. By the way, I had contact with somebody yesterday, then that can be, can apply in that situation, even though they've just started.
You know, Dan, you anticipated that there may be a question on the FFCRA, and goodness gracious, aren't you glad in law school they taught you about temperatures and social distancing and the like? You didn't mention this one, but Charlotte's asking the question, and that is, we've got this new term called essential employees. And so Charlotte's asking, when an essential employee is returning, is what you described, is it any different for an essential employee? And then there's a follow-up to that. So let's start with that first one.
Well, the Department of Labor does differentiate between the types of leave that are available for those who are sick, or could be sick, from those we'll talk about in a minute about caregiving, which doesn't involve anyone's illness necessarily, but involves most often the closure of schools because of COVID. Where the regulations, what they differentiate is if you have an essential worker, but that person is sick and their person is ill, even though they may be essential, there's not a provision that, as I understand the law, to allow them to be forced to stay at work or not, or be deprived the opportunity to take this leave, because the essential objective of this statute is to allow employees to avoid infecting other employees and customers. I want to make a point of that. Oftentimes we're talking about protecting customers and clients as well as our fellow employees. So hopefully it answers the question that even essential workers, my understanding is, are entitled to this if it's based upon their own health and protecting others from their infection or potential infection.
And I think, Dan, if I can follow up, I think what Charlotte might be referring to, because I recall reading a while back that for essential employees, for instance, if they believe that they have been in contact with someone, I think there's a provision that for an essential employee, you could have them at work as long as they are social distancing, practicing all of the care needed to not be exposed to others. So if someone believes that they've been exposed, but they don't have any symptoms, I think there may be, are there not some different provisions for essential employees to allow them to work under conditions where they can be away from others and wear a mask and take their temperature and so forth?
Yeah, I would agree. Thanks for clarifying that, Rhonda, that, yeah, if they can be protected from, or employees protected from them safely, then they aren't going to be entitled to this leave. And this goes back to the question that I looked like I may have overlooked, is that a key component of this statute, FFCRA, is that the employee is unable to work or telework. So if they're able to work remotely or work in an area that is away from others, then they are not entitled to this leave if those kind of accommodations can be made to allow them to continue to work. So hopefully that answers the question.
Yeah,
Well, it looks like it did. Charlotte says that you did, and thanks for the clarification, Rhonda. She kind of had a follow-up, and I believe it's related, and that is, but when you're asking an employee to be quarantined, how does the employee kind of, quote, prove that they were in fact quarantined?
Well, like a lot of this, it's just hoping for the best. I mean, to be honest with you, the better way to put it, I talked about a situation where they have other people in their homes that they live around, that you can instruct them, here's how you should go about separating yourself from your family members, staying separate, using separate bathrooms, for example, separate utensils. And the hope is that they are exercising that type of discipline for the required period of time. So employers in a lot of these cases are required just to act in the best faith they can, act in good faith. And so if you instruct that employee to quarantine for that period of time under these conditions, I've had some clients that in order to allow them to come back to work will say, I want you to be tested and have a negative test. So that is an option that you can do that's allowed under the law. But keep in mind, the test, the time frame for getting results has been reducing, but there's still going to be a period of time. If they get tested on Friday and they get the results on Monday, you're trusting the fact that over the weekend they didn't do anything else to become affected if they had a negative on Friday. So it's just immensely challenging, and there's no perfect way to do it. But my advice has been to make it very clear what's required of those employees to do the best you can to protect yourself and your fellow employees and customers.
Well, Charlotte kind of clarified and says, can we ask for documentation from a physician? Is that something appropriate to ask for?
Well, I think documentation, if she means test results, yes, that is something that you can. The Department of Labor, especially early on, commented and cautioned that sometimes it's hard to get a doctor's note, to justify that, but that is entirely lawful to ask for that and require that before they're allowed to return to work, especially in an environment where they cannot avoid close contact with other employees or other third parties.
Excellent. We kind of opened by acknowledging that we just passed through Labor Day, and for many school systems, they wait till after Labor Day to start. Some started prior to Labor Day, but the school starting back has created a whole new set of issues for a number of employers. The question that we got is, why don't we use this situation by which some school systems are given students the option of or requiring them to be in person certain days of the week and then do classes online other days of the week, which is kind of a hybrid approach. How does the FFCRA factor into when the employee has children at home some days and not at home at some days? How does all that fit?
This situation, what the qualifying reason that applies to the situation is qualifying reason 5, and is when an employee is unable to perform available work or telework, as I mentioned before, due to the need to care for a child whose school or place of care is closed or child care providers unavailable for reasons related to COVID-19. So critical terms in that qualifying reason are the school is closed. So the question becomes, in these situations with a hybrid schools, I've heard of some schools, I think even locally, maybe originally, they were open in person 2 days, online for 2 days, and maybe a day where there's no class at all. And so to address that, late last month, and in anticipation of these issues coming up, the Department of Labor issued 3 new answers to questions about the situation. So the answer to that is, and with a hybrid situation, we've got days where there's no in-person instruction available. It's all online, or there's no instruction at all. In that case, the school is closed for purposes of coverage under the FFCRA. And that can be, unlike what we talked about with paid leave, there is 2 weeks of paid leave and up to 10 weeks of paid leave for this particular type of reason. And again, a lot of employees may have used a lot of this at the end of last school year or even over the summer. So it may not be available to everyone. But it's also a key caution from the Department of Labor, and this is one of their recent question and answers was, what about, I think you mentioned, Mike, the situation where the parents are given an option. So you can come or you can stay online. If a parent chooses to not have their child go to school when the school is making that available, and they prefer for very legitimate safety reasons to not let their child go to school, then for purposes of that employee, their child's school is not closed. So that's something that employees and employers need to keep in mind, that if that's a decision that's made by the parent, then this type of leave is not available. And then the third question and answer they posted in the last month deals with schools that are open entirely online. And I think you probably see the answer to this one coming, that in that situation, the school is closed. The school is not available for in-person instruction. So in these situations, if you have an employee that is eligible for this, keep in mind that there's no additional documentation required to give this leave. The employee only has to provide notice of it within if it's foreseeable, which it should be, or within the first day. The federal courts recently made it clear that employers cannot require documentation be provided before the leave is granted. But my distinction that I've been making to this is, although the employee can tell you, by the way, boss, I can't work because my child's out of school, but before they are paid for that leave, there is documentation that is required. And essentially that documentation is taking the employee's word for it, that the school is closed. Here's the school that's closed. Here's the child that's impacted. And importantly, there's a provision that says you have to state that there's no other suitable adult to watch the child. Now, how's an employer ever going to know that? They really aren't. I mean, there's no way you can verify. If your employee tells you that it's up to me to watch my child, nobody else is available, you may have heard that grandma does it or Aunt Sue does it, but it's just an honor system. So that brings me to the point of tax credits. It's very important that if you give leave, you take their word for it and you pay the leave in these situations, that you gather documentation you need, which is representations from them, because the government has set up a system where you can get a tax credit, which is essentially a reimbursement for whatever you're required to pay, which is critical. I mean, that is something that's a great safety net for employers, that if they end up having to pay it, that they have a way to reimburse themselves. So it's very important to keep that in mind. That's something to work closely with whoever does your payroll and your taxes, your payroll taxes. So hopefully that answers your question, or maybe more than answers it. But if you got any follow-ups, or if there's some in the chat box about that, I'm glad to continue to provide the information I can.
I would like to go back from a follow-up standpoint in a moment. I'm also would like to turn to Rhonda, but before I do so, let me ask a question that Randy poses, and that is HIPAA. Employers are very, very familiar with the requirements of HIPAA. It's not just limited to the medical community and doctors' offices, hospitals, and the like. HIPAA has implications for employers. As a general rule, what do you advise employers regarding the confidentiality aspect of a positive test, negative test, whatever it might be? What general rule do you guide to your employers to kind of follow regarding HIPAA, particularly when it comes to COVID?
Yeah, HIPAA, the answer to that question is going to be very similar to what the answer would be to how does the Americans with Disabilities Act for employers with 15 or more employees under federal law, what kind of obligations they have. And I think the answer to both of those is very similar. Confidentiality is critical. So if you have an employee, to use your example used earlier, the employee comes forward and tells you, I think I've been either infected or I've had close contact, HIPAA would prevent you, and so does the ADA, from sharing that information with anyone who does not have a need to know. And so, for example, you don't want to go to the rest of your employees and say, John Doe is affected. Who's been around John Doe? You have to be very careful about having that information maintained confidentially, separately from the other employment files. The way that I've been counseling clients in this situation is that you go to the affected employee and say, can you identify who you've had close contact with so we can follow up with them? Because going back to the original question and answer, part of the process when somebody comes forward is determining who else among your workforce should be quarantined, who's had close contact with this person. And so to make sure you capture anyone who needs to be quarantined, but in that process, those communications need to be very careful, because that is protected health information. that needs to be literally protected from unnecessary disclosure.
Dan, what I'd like to do is I'd like to ask Rhonda some questions, and then what I would like to do in the time remaining is that we might have a little bit of a round robin fielding questions that are coming in on the chat box and issues that may have come up as either one of you all have been speaking. So Rhonda, I want to kind of turn to you. Dan just kind of gave an excellent recap of what the requirements are for employers. I think most people who have been part of this webinar series know we have a background in HR, and therefore oftentimes when you speak on issues, you are speaking from an HR perspective. As you're listening to Dan share all of these requirements, what type of things struck you as we just got to make sure we get that right?
Yeah, there's actually a few things, and Dan, thanks so much for the updates because they're very relevant. And even though I think a lot of people are familiar with FFCRA because it came out, we hit it real hard the first few weeks, but I think with school in now and some of the changes that companies are adapting to, the update is very critical. And just to follow up on something you just mentioned that Randy asked about confidentiality, I know a couple of situations that we've worked with clients on is, well, we only have 15 employees. So when one's out and we start asking who's been exposed or letting people know, they're going to know who it is. And
Right.
yeah, they probably are. But I think the critical part is as an employer, you cannot reveal that information.
Exactly.
And even if asked, well, I know so-and-so's been out sick for a week. Did they have COVID? As an employer, you can't comment on that. But as you said, you do have to do your due diligence to find out who's been potentially exposed and just notify them, we believe you've been exposed. And so here are the steps that we need to have you take. But under no circumstances should you be revealing an employee's name, even if other employees know who it is or think they know who it is. So, and smaller companies, you're right, they're going to know. But as an employer, we can't reveal that.
Exactly.
Couple other things, I think, just to clarify as well, we may have stated this up front. Most people should know that the FFCRA applies to companies under 500 employees. And that doesn't mean if your company's larger than that, that you can't provide those same types of benefits. The difference is that they're not tax. You can't get reimbursement from the government. So one thing I would just encourage companies to do is take a look at your leave policies with all of the changes we've gone through, with different things you've experienced with your employees. You might want to take a look at what your leave policies provide. And again, FFCRA is going to be gone as of December 31st, as far as we know it now. So there may be things that you want to put in place to continue to provide some time for employees, because I don't think COVID's going to be gone December 31st. So you may want to look at what your policies provide, whether you're a larger or smaller employer beyond December 31st. And I think with a lot of the changes too, it's extremely important to proactively communicate to your employees what's available to them. Again, some people might have used it already, don't have it available. Maybe some people haven't. And I think with the school situation and the things that you outlined, Dan, with, every school is different. Some are virtual, some are not, some are in person. There's a hybrid. Parents are making choices, but I think it's very important to outline to your employees what their options are as it relates to the paid sick leave, depending on the school's situation with their children. So proactive communication is going to save, I think, a lot of questions, a lot of grief, a lot of time. And we've helped employers put together some Q&As and some guidelines. So we're more than welcome. We're more than willing to help with that if it's something that you need. Another situation that I came across with a client that I think would be worth mentioning is, had a client who a while back said one of the employees came and said, I believe I was exposed to COVID over the weekend. So told him, okay, you need to go get tested and you'll be off work until you're tested negative. So he did test negative, came back, and then a month later came and said, I think I've been exposed to COVID. And the employer said, I really think he's just trying to get time off of work. And I said, then you got to give it to him. You can't question. And I know it puts employers in the spot. And again, all of the FFCRA, the regulations, the time off is to protect employees. So we have to keep that in mind. And I know employers can sometimes get frustrated because there definitely are some people that have taken advantage of these benefits available to them. But you have to keep in mind that if you question or you tell employees that you don't believe them and they have to be at work, and then someone else gets infected, you have a huge liability issue. So we do have to give the employee the benefit of the doubt unless you have real strong reasons to believe otherwise and, can address that. But I think one thing with that situation too to point out is if someone says that they've been exposed to COVID, but they don't have any symptoms, and we want them to be off work to be tested, they're not going to be eligible for that paid sick leave while they're waiting for a positive test if they are asymptomatic. And that's correct, right,
Right.
Dan?
That's correct. It doesn't seem to make a lot of, that's the
Right.
way the statute reads, right?
Yeah. So that's something else to keep in mind. If someone, multiple times believes that they've been exposed and you require them to be off for testing, you don't have to pay them for that time unless they have symptoms or unless there is a positive test. So that's going to hopefully be a discouragement for people doing this multiple times because they won't be paid.
Well, unless they've got a doctor who's recommended they be quarantined.
Yeah.
And, we know that sometimes there's doctors who will provide whatever you ask. So that is a possibility. But to your point, Rhonda, the regulations are clear that if an employee self-quarantines just on their own, that they are not entitled to it. And then they may be doing it for good reason, but if it's not at the direction of a healthcare provider, they just do it on their own, they're not entitled to this leave.
Yeah. And I'm curious too, Dan, I think this is maybe something that could be on people's minds with the new school schedules. Let's say there's an employee who's not used any paid sick leave, has not used any family leave for their children being out of school, and they're now going to take intermittent leave. For instance, their kids are home 2 days a week, and so they're going to take 2 days a week of family leave. Can they still use that paid sick time for those first 10 days of family leave if they're using it intermittently now for the school being closed?
Yes, and that's one thing I forgot to mention before. I want to make sure I point out in terms of what the federal court recently, their decision that impacts how this plays out. And that goes to the point of intermittent leave. Originally, the statute and regulations were that for an employee to use it intermittently, like 1 day a week for the next however many weeks or 2 days a week, it had to be with the permission of the employer. For the caregiver aspects of it, not the health based, but the caregiver part. The federal court has now said, and the Department of Labor has not issued any response to it. So I'm advising employers to comply with the federal court decision. Is that is now a decision that is entirely up to the employee. The employee wants to use it intermittently and qualifies for it, cannot work because of that, they can take it intermittently. One of the things that I wanted to mention that came out of that decision is that many of you may know that there is an exemption that an employer has the option to take if you have an employee who's requesting as a healthcare provider or a first responder. Originally, healthcare provider was defined, I thought it was so broad, it was like basically anybody even worked in a doctor's office, or they used the example of at a hospital, somebody who worked in records or something. The federal court says that is just overly broad. And so for those who have employees who are healthcare providers, keep in mind that that ability to not provide it, to exempt them from it on a case-by-case basis is much more narrow than it once was. So I just want everyone to keep that in mind if that would apply to them.
Dan, I know that much of what we talked about has been more in a legal area. This might be more of an accounting question, but David is saying, we're having to keep up with all of these records on when people are taking leave, paid sick leave, paid family medical leave, and the like. His question is, to your knowledge, is there a specific tax form that employers will need to be submitting that capture that information at year end?
Not that I'm aware of. The IRS has clarified what information is necessary to be able to claim the tax credit and broken it down by qualifying reasons. And I prepared, and I'll be glad to make it available to David or to you all to distribute to those on the call. It's a request form that includes the information that is necessary to justify that tax credit, because that is what the Department of Labor says, is you can ask them for whatever information that is necessary to obtain that tax credit. Originally, the original regulations and commentary on the statute was that you could require your employees to, for example, bring a doctor's note or bring something from the school that says the school is closed. IRS says we don't need that much. IRS says in order to get the tax credit, we just need representations of what the situation is without any underlying proof, which is, like I said before, creates a huge situation of the honor system in play. But the safety net, again, for employers is that the information that IRS has said they need, I'm not aware of any forms at this point to actually demonstrate that. I think, as I understand the process now, you can claim the tax credit as an employer, and if that is ever challenged, that's where you'll need to have this documentation tucked away to say, oh, here's why we feel like we were entitled to it for this particular employee. You don't have to, as I understand the system now, don't have to produce that when you take the tax credit, but take the tax credit and be prepared to defend it if necessary.
Excellent.
And the tax credit, as I understand correctly, Dan, is taken on your quarterly payroll tax return.
Exactly.
So taking that credit is done on a quarterly basis on your payroll tax return, but I haven't seen or heard anything either that needs to be submitted as far as documentation, but to definitely have it available.
Have it ready.
In case it's
have it ready.
Yeah.
So if there's no telling when the IRS is going to get around to, if they do, to trying to figure out who's entitled to it or not.
Yeah.
But if they do, having that information readily available at that time would be very helpful.
We are going to begin our wrap up here. So I would like to ask maybe the same question of both of you. I want to start with Rhonda. Rhonda, we have covered a lot today. But there may be some things that you kind of say, you know what, we need to go back and revisit something. What might be some things you want to make sure that we do here before we sign off on our Q&A today?
Well, I think most importantly, the updates that Dan's provided, it's really critical to stay up to date with the changes, because just as this started, it started fast and furious in March. And on the first few webinars we had, we were sharing what we knew, but what we knew was only what was being published, and what was being published was very limited until everybody figured it out, because it was being figured out as we kind of went along. And there's been continual changes to CDC guidelines, continual changes and updates to the FFCRA. So I think, just staying up to date on those changes and making sure that you're communicating that to your employees is really important, because a lot of people may have not been affected by this, or maybe you've had people off work for several months that might just be coming back. And so providing them with these updates, with this information, is really important. And anything we can do, if you have questions, we field questions from a lot of employers, a lot of clients on scenarios that come up. I'm not sure how to handle this. Haven't had this come up before. We're more than willing to help with those questions as you have them, to make sure that you're handling appropriately if you haven't before. So just reach out to us if we can help in any way.
I went ahead and put the contact information up so that people have that for Dan and for us. So I'm going to ask the same question of you, Dan. What might we have not covered that we really should have covered?
One thing I wanted to touch upon, and I mentioned it very briefly in our discussion of what initials stood for, what is the Payroll Protection Program. That is something else like the FFCRA, actually more so than the FFCRA, has changed and evolved this year, as it was originally rolled out with the thought of it being something that would wrap up in 8 weeks from its initiation in April. Has been extended now in various ways to the end of the year. So I would encourage anyone on this call who watches the recording who has taken out PPP loan, and particularly those who have elected the available 24-week covered period. You've got till the end of the year to restore your payroll, to restore your FTEs. With everyone's objective is to achieve maximum forgiveness of that loan. I mean, it's unique in the sense that there's a potential there to be able to have all of it forgiven. And in order to do that, you want to avoid any reduction in that. And so be thinking as you're looking toward the end of the year for opportunities to bring employees back to work, to restore their pay before the end of the year, and to restore your full-time equivalents to where they were pre-pandemic. So that's just something I wanted to remind everyone about as we hit the home stretch for that program. And like Rhonda said, the FFCRA is good at the end of the year. Who knows what will happen beyond the end of the year, but right now that's where we are with that particular program and the opportunities to make sure that employers do what they can to have as much of that forgiveness as possible.
I want to go to one more slide here just so we kind of actually have that. When we came together, our first Q&A session was on March 25th, and we began these sessions to kind of address the questions that clients were asking us. This is our 24th weekly webinar. I cannot believe 6 months have passed.
Mm-hmm.
But we're so flattered that hundreds of you have registered to attend a webinar. A number of you have been with us most every week, and for that, we're very, very, very grateful. We last week announced that we would be transitioning, and we learned that Dan would be available. We said, we're going to put one more webinar on the calendar. And so what we did here is that a number of you had asked, would we consider maybe changing this format, maybe to a podcast, maybe a 30-minute podcast of bringing in the same high quality guest like Dan. And that would give the folks who are listening opportunity to kind of listen at their convenience. And so we kind of concluded that's a great idea. So we are converting this 60-minute live webinar to a 30-minute podcast, and we're entitled that Get Unstuck and On Target. Because what we're hearing is what gets our phone ringing, our clients that says, we're stuck. Can you help us get unstuck? And if you look back at all the great panelists we've had, they have offered some great suggestions. And so we think that will fit what is it we're trying to do. Thursdays has been somewhat of a tradition for us. And therefore, we will be launching this new podcast next Thursday. That will be Thursday, September 17th. And we've already lined up some great guests. You'll be getting an email inviting you to subscribe to our podcast. You can use your favorite platform, be it iTunes or Spotify, but we hope that you will subscribe, and we hope that you will invite your fellow leaders to subscribe. We know that a number of you would prefer this individual format, kind of like what we're doing here today. So we're also going to be uploading this podcast on YouTube. So you can subscribe both to the podcast or to our blog by just going to our website, bench-builders.com. So again, I want to thank Dan, you for your willingness to come back on as an expert panelist.
My pleasure. Thank you. Thank you for the invitation.
Well, I always enjoy listening to you. And if people can note, I'm writing things down so very, very fast. You've given us lots of great information, and I appreciate that. And Rhonda, you were able to kind of dovetail with what Dan was saying. And as always, you're able to offer perspectives that we need. Thank you.
Thanks, Mike, and thanks, Dan. We really enjoyed having you with us again and providing some great information for our attendees. Thank you.
Well, thank you again. Thank you again for the original invitation and the follow-up. So I really enjoyed the time.
Well, Dan, you had the distinction as the only guest that we invited back a second time.
Thank you very much. Very flattered. Thank you. I hope it was very helpful both times.
Well, without a doubt, it was very helpful. We will call that a command performance. So
right.
Thank you, Dan. Thank you, Rhonda. And most important, thank you, the folks who have registered for these webinars. We hope you have found value in these Q&A sessions. And so on behalf of Rhonda and me with Bench Builders, thank you for tuning in. Thank you for your ongoing support. Go out there, make it a safe day, and God bless. Take care,
Thank
everybody.
you all.